what do you think? No, no, no. No, no, no. What have I proven to you? What have I convinced you beyond a reasonable doubt occurred in this case, so much so that you don't have any reasonable doubt as to those issues that I presented to you? They are supposed to use words like certainty and definite and without question, beyond a reasonable doubt. No other explanation. These are the words and phrases of good prosecutors. I used to be one. I know. I've used them. What aren't good words of good prosecutors are maybe, what if, I hope so, you figure it out, could have been. Because those are the assumptions that please do not make. Do not cheapen your role in this case by doing anything less than holding them to the burden that they said in the beginning of the case they would gladly accept and prove to you.
Shortly thereafter, Anne-Marie.
All right, folks. Welcome back to the Steve Malzberg Show. Joining us right now is our friend Jeff Weiner of the Orlando Sentinel. Hey, Jeff.
Hey, how's it going?
Good, good, good. All right, so we were listening to Mark O'Mara there and his closing arguments to the jury, and then, of course, the rebuttal by the prosecution. How do you think it shaped up and went? Of course, the jury has had the case now for about 3-4 hours.
Yep, we're looking at about 3 hours and 23 minutes of deliberations now that the jury has been back there trying to come up with a verdict. They've only had one question so far. They asked for a list of the evidence in the case, but otherwise we haven't heard from them. As for O'Mara, I think he heard what everyone was saying yesterday, which was that the state's closing argument seemed more like a defense closing argument. It was highlighting inconsistencies in George Zimmerman's statements, things like that. He came out today and did the opposite. He said that he could prove George Zimmerman's innocence, and of course that's something that he's not required to do. The defense doesn't have to prove anything. But basically he said, all of the evidence, every scrap of it fits George Zimmerman's account. He told jurors that Trayvon Martin's death was a tragedy, but he said you can't let sympathy play into it. Welcome to a criminal courtroom was what he said after that. So it was a very clinical breakdown. He went witness by witness. He used that animation that was so much discussed earlier on to show them what the defense believes happened between the two of them, and it was 3 hours, and the jurors were riveted by all accounts.
And he used something that I don't know if he anticipated what the prosecution would do in rebuttal, or if the prosecution did this in direct response to what O'Mara did. But there was 4 minutes of silence. Right. 4 minutes of nothing. And O'Mara said that's the amount of time that Trayvon Martin could have gone home. But he did not go home. And then the prosecution comes out and says nothing is more frightening to a child than someone following them on the way home. If it had gone in reverse order, it might have been more effective for the defense. But I think it was pretty effective for the defense nonetheless.
I've actually heard of lawyers doing exactly that before. It's a very, it's a very compelling approach. When you're trying to demonstrate to a jury that a period of time is longer than they might think it is, have them sit in the courtroom in silence for that period of time. And it felt like a very long time, that 4 minutes. And basically the point that he was driving home, which they've made before, is, if Trayvon Martin was running home, he had more than enough time to do so. The state, as you said, kind of tried to turn things around. They've in all of their arguments and statements referred to Trayvon Martin as a child, as a kid, as an innocent kid. They did that again today. Prosecutor John Guy gave a possible explanation for why Trayvon Martin didn't go home, though not one that anyone's testified to. He said, if you were being followed by someone through a dark neighborhood, would you lead them right back to where you were staying? He basically said, that George Zimmerman, the defense's animation starts when they encounter each other at that sidewalk T, as it's been described. But John Guy said it started before that. It started when George Zimmerman got out of his vehicle.
Which of course it didn't. I mean, the episode did. The eventuality of their meeting did, but that's not where they met, of course.
Right. I mean, that's the debate that's happening here. The defense has tried to focus on very specifically on the conflict between the two of them, which the state has not really been able to do because no one saw how it started, except for George Zimmerman, obviously, and Trayvon Martin, who can't testify. So basically, it's been a tug of war between the two parties. And John Guy, one of the interesting things he said was he told jurors that focusing on how the conflict started, the physical conflict, is like reading the last chapter of a book. And the state says that book starts basically months before, with George Zimmerman being increasingly frustrated by other crimes in his neighborhood. Who knows how the jury, which side they came down on, but there's certainly a wide gulf in perspectives for them to decide.
And of course, one of the things that the defense had wanted and might use on appeal was that they wanted the judge to instruct the jury that it is not against the law to follow someone, to leave your car, or to even confront someone.
Right.
She refused to do that, and that might be a point of contention later on. All right, listen, so we got 30 seconds. I've had different predictions from different people today on how long they think the jury might be out. What's your guess?
Well, we were thinking it would be pretty quick. At least that had been the thing I'd been hearing the most early on. But we're at 3.5 hours now, and the jurors asked for a list of every piece of evidence in the case. So that's probably an indication that they think they've got some work left to do.
All right, sir. Thank you for everything. We'll speak to you next week, one way or another. Jeff Weiner, ladies and gentlemen, from the Orlando Sentinel.